conclude
I'm
your
89
hearing,
years
Mr.
old. I just want
Wallace.
to live in peace. I don't need this harassment from them.
All right, that's all for today, Mr. Wallace.
You should have known they'd protect her.
Okay, now next will be Danielle and Brian Johnson versus Kelly Phoenix. Okay, all right, and Miss Phoenix, I see that you were served with the notice of the hearing on July 8th. Are you ready to go?
Yes.
Okay. All right, thank you. All right, and so same thing, I'm going to swear the parties in here. The Johnsons are the petitioners here, so they're going to get to go first, and then I'll hear from you, Miss Phoenix, and make a decision, okay? All right, so can I have all you raise your right hands, please? And do you each swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, so I'll hear from the Johnsons first.
Okay. Do you want us to start? I know you have all the paperwork. Do you want us to start from the beginning, from the 2 years ago, or 2 years of this?
Well, it's really up to you, but you know, do keep in mind that I do have your whole petition here, which is made part of the record, and I'm aware of it.
Okay. So basically, you know, this has been 2 years ongoing with Kelly. She was a member of the gym. She started stalking our grappling instructor, Paul. He is a lawyer, by the way. She sent, you know, over 100, like 125 emails to him during the day. So we had to let her go out of his class. And when Brian would explain it to her that she can't take it because of her mental illness, you know, she's diagnosed schizophrenic and she has psychosis. I've also talked to her two sisters, one that she lives with, that says she doesn't take her medications, and her estranged husband, but she was under the impression that Paul had this thing for her, as she did with everybody else in the gym, telling Brian, well, you don't see it, you don't feel it, you don't see that energy. And Brian's like, no, you know, he does not want you in the class. Like, she was just, it was just too much. And so she kind of just stayed to herself in the gym, walked on the treadmill. And then soon after that, she had in her mind that Brian wanted to be with her. And that's why Brian kicked her out of Paul's class. And then she started in with Brian. And so Brian we had to kick her out of the gym because it was just, she was just getting crazier and crazier. So you see all the stuff that she did. She sat behind his car several times when he was leaving the gym, sent him flowers, sorry. All those texts, emails, trying to get together, trying to have drinks. She did that also to a couple other guys in the gym. Then it kind of died down a little bit. She put a horrible email out, or a text, or sorry, a Facebook message that you have a copy of that, that she took down after I confronted her with that, but it got out to members. And then she kind of died down for a while until a couple of weeks ago, where she started sending out those emails about those horrific things about our daughters, Brian, and then the second one stating that Brian and I did a murder to hire here and all this crazy stuff. And we have all the proof for that. We're just doing a civil suit on that part of it. But what we're concerned about, and also the police officer in South Carolina states, because of her mental instability, he's concerned her blasting these emails out to businesses and members that somebody is with our addresses, our kids' names, that somebody is going to believe some of that stuff, and they're scared for our livelihood or what's going to happen to our business. And Kelly has said about 5 months ago, her estranged husband said she was going to come back here, and she has it in her mind that she is welcome back into our gym. And so our members are afraid. Our kids are afraid of her, because she's not well. And we're just trying to protect that. And I, you know, if she does come back here, I don't know why she would come back here. Her estranged husband and kids both have restraining orders on her, so she doesn't have anything here. But being her mental illness, I just don't trust her at all with what she's capable of doing. And then her husband, we have a letter from him to ex-husband, or soon to be ex-husband, said that she was trying here to get a gun. She really wanted to get a gun. and he was afraid of because how she was talking about me. Because, you know, she thinks that Brian wants to be with her and I need to be basically removed from the situation. So yes, that's about all. But you have all the rest. So we're just really afraid of what she might do or what she's capable of.
And Mr. Johnson, did you want to say anything as well?
Just, that's pretty much it, Your Honor, in a nutshell. Just, she's showing up to our gym after I've removed her from the gym, blocking me in behind my vehicle. I've taken pictures of that. She's been sending me flowers, emails stating that she thinks that we have this thing between us, which we don't, which I don't understand, because she's never really been in my groups in my gym. She's been with everybody else, and how this turned from my grappling instructor to me, I just can't fathom it. I don't understand why she's doing this. And she's done this to a couple of my other members of my gym, that she's wrote them letters and emails and so forth. And these are married men. And finally, I had to remove her from my gym. And then that's when the hardcore stalking started, where she was showing up behind my vehicle at 9 o'clock at night, blocking me in. And I called Lacey PD when this happened way back. And they were saying, get a restraining order. I should have back then. I thought it was going to go away. And then the crazy Facebook post stating that I broke into her house and put video surveillance cameras in her house. I put trackers on her phones. Then the final one is she's emailing all my sponsors to my Northwest Fight Challenge event and all the members of the gym, stating that I raped my kids and that I raped all their friends. And then she's stating, and she wrote another email out to everybody, blasting it out again, that my most favorite, that I've confided in her, that I'm raping, and my most favorite is my adopted sister, which I don't have an adopted sister, but she's putting this crazy stuff out there that my favorite person I'm raping is my adopted sister, which I don't have, and so forth. But I mean, it's just, I fear for my wife, myself, my kids, members of my gym, that this lady that it clearly has mental issues is going to show back up here in the state of Washington every day since I've removed her from my gym. When I open my door to leave the gym, I scan the parking lot looking to see whether or not she's going to be around the corner with a gun, that, something bad's going to happen to me or my family, because if she can't have me, nobody can. Or if she removes my wife from the situation, then we're going to have whatever she thinks in her delusional mind that she's going to get. I just want her nowhere around us because she's unstable, and I just want to feel safer in our business, our home, from this lady that's clearly mentally ill. And so, and you have everything there that she's been doing, the emails, everything, and she's blowing my home address out to emails to people. Like my wife was stating, if one person believes this, are they going to come and try to burn my house down? Are they going to try to do something bad to me or my wife or my kids because they're going to believe what she's stating in these emails, that she's putting my personal address and my kids' name into? I just want it to stop, and I want her to be away from us, and a restraining order will restrict her from, there's consequences if she disobeys a restraining order.
All right, thank you both. Okay, Miss Phoenix, it's your turn to tell me your side of it.
Okay, deny or refute a lot of what they said. It's outright false or wild warped exaggeration. Now, I did file a mutual restraining order against them. However, unfortunately, it was not there in time. I think I filed it. I sent it to the wrong email address. You may have some things I've already submitted. So I do have a mutual restraining order request on both of them. And I also have a police report made over years ago. So when I joined this gym, it was in 2015, and he kicked me out of his gym in 2017 as a direct result of having rejected his sexual advances towards me. And so a lot of this happened a long time ago. I deny any kind of stalking behavior. In fact, I have accused him of stalking me, and is why I had to leave the state. He clearly admits to having called my family, my husband, completely inappropriate. He has information and inaccurate information about that. He's also been the one posting things on his business's Facebook page. The petition I have submitted and will submit a more thorough one today at the correct email address. Will show the evidence that I will submit about things that they posted, things that they texted as well. Danny Johnson called me, threatened me. Brian Johnson threatened me as well. I prepared a statement to a declaration in response to this, if I may read that.
It's your decision.
Okay. Okay, I declare that I've never stalked their employee, which was one of their claims, and certainly not continuously. The employee that Brian Johnson is presumably referring to is Paul Boudreau, who is Brian Johnson's jiu-jitsu instructor, as well as his personal attorney. Paul is also my former jiu-jitsu instructor. Now, Paul was the one who kicked me out of his class after I was in his class for almost a year, and it was through personal issues with him and I. It was not Brian who kicked me out. It was Paul, and not as a result of stalking or inappropriate behavior. He thought I was disrespectful to him in class. Regarding the statement that I sat in behind my vehicle and behind Paul's vehicle and waited for him. On roughly 2 occasions, upon leaving this gym for the night after that jiu-jitsu class ended in 2015, every weekday, Paul Boudreau was actually the one who started sitting behind my car several times at night. Now, I didn't think this was stalking or inappropriate. I just assumed this was chivalrous kind of behavior because it was dark. But we never talked about it. And so I did the same to him on only 2 occasions, mind you. But this is certainly not an example or evidence of me stalking him. But in Brian Johnson's own petition, he clearly admits that he inappropriately contacted both my husband and my lawyer, as well as my sisters, after I had suffered a nervous breakdown. As a result, I believe was there stalking me, not only stalking me, but defaming me and slandering me in the whole community there, such that I felt the need to flee that state. I plan on finally be able to afford to hire a lawyer and subpoenaing some poor witnesses and having a civil case against them and having this finally proven. But I have not been able to afford that. My divorce settlement is next month. I will be returning to Washington then. Hopefully, I'm anticipating having some funds in order to do this.
It's like we just lost Miss Phoenix's connection. All right, we'll stand by for a minute here. There we go.
I'm sorry, my phone cut off. May I continue?
Yeah, we just lost you for a couple seconds there, so you can pick up where you left off.
Okay. In his own petition, he clearly admits that he's inappropriately contacting both my husband and my sisters, getting information from them. I did have a nervous breakdown a couple years ago. I had never had any mental issues prior to that, certainly not when I was a member of their gym. And the diagnosis, which I refute, I believe is erroneous and ultimately was defined as related to marijuana usage, which I no longer even use. It's not legal in South Carolina. I have not used that for a while since moving here. I've made 2 separate police reports about the stalking behavior by Brian Johnson, but unfortunately was not able to obtain the copies of those reports in time to include with this response. I was actually hoping to have an extension, if that's possible, for evaluation of these, what will be mutual petitions for protection, restraining orders. I've also submitted my own petitions for protection. They were filed this morning. Apparently, I sent an email. It's the wrong place, though you may have some I did file correctly a couple days ago. I suspect that the main reasons they have filed this petition, which I'm not even in the state, I don't understand why they think I've been stalking them. I certainly never walked far. So I suspect that the main reasons they filed this petition, is to attempt to thwart me pursuing further legal action against them, both civilly and criminally, as in the protection order, there was a request to prevent me from engaging in any further legal action against them. It behooves them to make me look insane as defense and distraction from my own old as well as ongoing accusations of their stalking of me. It is a very timely action of theirs, as I will be returning to Washington next month to finalize my divorce from my husband. And I feel threatened from Brian Johnson and Danny Johnson, both of them of which have threatened me. As I've long suspected that Brian installed or had someone install stalkerware or spyware apps on both my cell phone and laptop that I left unattended in his gym, they would have been privy to this information. I'm anticipating receiving money for my divorce settlement, at which point I will finally be able to hire an attorney to subpoena some critical witnesses that can corroborate a definite pattern of defamation that Brian has been applying to me in retaliation for having rejected his sexual overtures towards me. His being rejected by me is why Brian Johnson kicked me out of his gym one day after I had rebuffed him. I definitely do not believe that I'm welcome back in his gym, nor do I want to be. I never want to be in that place again or see him or see any of them. I suspect Brian Johnson to be a predatory, malignant narcissist who has a definite warped sense of reality and gaslights everyone. He is a former part-time Tumwater, Washington police officer. The day after he prematurely ended my gym contracts, I went back to his gym to attempt to speak with him. He'd been very upset and he kicked me out. When I did so, he threatened me with the, quote, dossier that he had told me that he had been compiling against me. Very private information from my life that he should not have known, which led me to speculate that he still has and abuses access to the private confidential information in the Tumwater police database. I've never signed John back to his gym on occasions to attempt to talk to him in his situations. And again, that was in 2017. And though I was not interested in him, I'd been friendly with him. I sent many emails to him following being kicked out of his gym. I sent a lot of emails to Paul, but that was throughout the year I was his student, not afterwards. And I have not since sent any emails to Paul Boudreau. So this was about 7 to 8 years ago. I've not sent any emails, called them, seen them, or made contact with them since then. As my husband and I have been engaged in an acrimonious custody battle and prolonged separation, my husband was able to acquire sole custody of our kids through duplicitous means. I was never a threat to my children. It had nothing to do with any mental health issues. It was ultimately a misunderstanding, and it's something that I hope to rectify very soon in my divorce settlement. I'm not sure what emails Brian Johnson is referring to. And also, when I received this petition, I didn't receive any kind of, I don't know what it says he attached some evidence to his case, but I didn't receive anything like that. And I had been under the assumption that that had to be included. So I seek for a continuance of this, and I have all of my paperwork ordered.
All right. Thank you, Ms. Phoenix. All right. I'm not going to grant a continuance. I was clear in the beginning. I asked the parties if they were ready to proceed, and all the documentation was filed with the court in a timely manner. So I don't see any reason why any exhibits or any other documentation wouldn't have been available to the parties well in advance of today's hearing.
Sir,
so, yeah, Ms. Phoenix, I'm going to ask you not to. Ms. Phoenix, I'm going to ask you not to interrupt. Okay. I'm going to actually insist on that. This is the part of the case. Now I've heard both sides. I'm going to tell you my decision and I'll explain why I made it. That's not an invitation for you to interrupt or argue. Okay. If you do, I'm going to have the clerk mute your microphone, and that'll be your end of participating in the hearing. Clear enough?
Yes.
Okay. All right. So the parties have presented their cases. The Johnsons are the petitioners with the burden of proof to show by a preponderance of the evidence they're entitled to the order that they have asked for. And they, in my view, based on the testimony that they provided today and the exhibits that they provided as well, that this is clearly a case where they've established that stalking has occurred. They've supported that through their testimony as to the actions of Ms. Phoenix. They've supported that through the various letters and emails and other forms of communication by Miss Phoenix that they have found to be upsetting. Those things have gone on over a period of time. They're targeted at the Johnsons. They clearly express a desire that the Johnsons should be placed in fear for their safety, not only from Miss Phoenix, but from other people that she is attempting to create the impression that the Johnsons may need to fear as well. This is all obviously coordinated or linked in a way to make the Johnsons feel intimidated and scared at all times. And based on their reaction to the various kinds of communications, they have been scared. And a reasonable person in their position would be scared based on the actions that Ms. Phoenix has taken. There's no lawful purpose to any of this. The only caveat I'll say in that is that if there's any litigation related to defamation or what you folks have referred to as libelous statements or slander, that's beyond the scope of this court's jurisdiction in this matter, and that would have to be decided separately in a different kind of legal action in a different court. So I'm not making any pronouncements about the validity of any kind of defamation or whether any of that's actionable. I will therefore grant and enter a stalking protection order protecting the Johnsons. And I'm going to place that order in effect for 5 years. All right, I've signed the stalking protection order. As I've indicated, it's been reduced to writing and it will be available to both parties. The court clerk will send you each your copies.
Thank you so much.
Thank you, Your Honor.
All right, you're welcome. And that'll end the hearing for today. And Kayla, we've got
Go ahead. I'll let you address mine before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that there's a case out of 14A2, 25203, or, oh, sorry. Okay, actually, no, I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that
Out of my court?
Oh, sorry, 1482.
So what would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far as this
but I
matters,
won't.
yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged, alleged, conduct in the police report, as far as that report, which, we have not had any substantive, hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have, stood mute on that matter.
Yeah, screenshots.
Yeah. And we do, we are gathering discovery on the matter. I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell.
Got her moved.
Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address. Yeah, okay.
You're saying the bond I set was excessive?
Well, at present, given the
Okay,
current
go ahead.
circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her.
Where are the other two children?
My kids were left at
Yeah.
home attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home attended for 2.5 weeks. I sent cash up money to them.
This is Ms. McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with their grandmother.
I got the move. I just want you to know that, sir.
And Ms. McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just.
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir, and that is taken care of. And it was just you prosecuted her rapist, and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds, and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, the court's familiar with this case. I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since the last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is being stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police, she had to text a friend to call police because she was so afraid of her. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case, and I believe in our bond form, our original request was 100,000, so I think 50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And
Again,
her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say I don't believe I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case, with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider.
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an act.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact, in addition to the fact that there would be a GPS tether as part of her bond conditions.
And Your Honor, I did also want to make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I mean, I do have concerns. She does have an assault history, and given this case, I'm concerned that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will continue.
And Your Honor, did we set a date?
I don't know. July 3rd, 1 week out.
Okay, let's start with Shankster and Carpenter versus Johnson. Okay, that's number 25-187. All right, this is Carpenter and Shankster's petition for anti-harassment order against Johnson. All right, so I'm going to tell you a little bit about how this is going to go, and this will apply to every case where we have a hearing this morning, so this applies to everybody. In these cases, I'm going to call the case, I'm going to swear the parties in, and then the petitioner will present their case first. The petitioner is the person who initiated the case by filing it in court. I'll listen to what the petitioner has to say. Then after that, I'll listen to what the respondent has to say and make a decision as to whether to issue an anti-harassment order. It's the petitioner's burden to prove by a preponderance of the evidence that they're entitled to an anti-harassment order or a protection order. During the time that the other party is telling me their side of the case, I'm going to ask that if you hear that other party say things that you don't agree with, that you don't believe are true, to not interrupt them, to just let them tell me their side of the case, because I'm going to give you the same opportunity as well. So when you tell me your side, that other party won't interrupt you either. I may need to ask you questions once in a while just to make sure that I understand what you're claiming or what your defense is, or if I need clarification. And then I'll tell you what my decision is, and I'll explain to you why I made the decision that I did. So the other thing I'm going to ask you to keep in mind is that mostly I'm going to decide these cases based on information that you filed in writing, if you filed in writing. And then the testimony or the statements that you give me here today orally, you don't need to repeat the things that you've already said in writing. If you've made a statement in writing, if you filed that with your case or in response, then it's already part of the record and you don't have to say it again in order to kind of make it real. So keep in mind, I've already got those and I've read them. So, all right, we're going to get started with Carpenter versus Johnson, Carpenter and Shankster versus Johnson. Can I have the parties raise your right hands, please? All right, and do each of you swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
So Carpenter, Shankster, you are the petitioners here, and go first. Go ahead.
Thank you. So the reason why we're asking for this order, we did provide quite a few, statements with the petition to begin with. But basically, we've lived in our house for maybe 6 or 7 years. During that period, we never had a problem with our neighbor at all. We even, I would babysit her kid. Basically, they would, her kid would come with me to work, hang out with my boys. We never had any problems at all. I became mayor of the town of Bucota about a year ago now. And since then, the town has had some, in my mayoral or work type duties, the town has had some issues that required my neighbor Danielle's water to be turned off due to lack of payment. There's no way that I personally can turn her water back on, but it's gotten to the point where, we've had a 2-week reprieve, which has been really nice, but I haven't even been able to go out. My son will go out to the car, and if Danielle's out there, she will yell derogatory things. And we've submitted evidence from our recording, our cameras, showing that, we can't go outside without her yelling at us, basically. And it's all really inappropriate things that my son shouldn't have to hear me be called, my husband be called. And all while I can't change what the town has decided to do based off of, my neighbor's actions. So that's why we are requesting for my husband, me, and my son, the no contact order.
Okay, and I did read that in your petition and the documents you submitted in support of that, and mostly in the form of texts. I think there was one video and a image as well. Okay, is there anything else from either of you?
No,
you said it all.
All right, then Ms. Johnson, it's your turn to tell me your side of it. I don't think you submitted anything in writing, so just, this is your chance to tell me your side of it. And you're currently muted.
Okay, sorry about that. So I just want to say that first of all, the last name is not Johnson, which they have filed it under, and I would like to say that the reason I contacted her on her personal phone was because I've gone to the town hall and they've told me that they can't help me or to call their lawyer, but they won't give me the lawyer's name. And when it was a hot day, I have the right to ask that my water be turned on, as well as my water has been paid now. And I'm not even allowed to go down to the town hall because it's where she works. But my problem with the whole situation here is in her statement, It states that that she was out walking and my husband pulled a gun on her. And my husband's been incarcerated in Eastern Washington since February of 2024. His DOC number is 745-862. So that whole situation there is irrelevant. And I'm fighting a foreclosure right now that was illegal. I'm going through a lot of things right now, and not having water and this whole situation is not, it's not all right. I have a child in the home, and it's not right. And I can't even pay it. They won't even let me pay whatever's left on it. So, yeah. And I've never said anything directly to them or said, hey, this person or that person. I mean, I could have been talking to anybody. Never directly to them did I say anything, other than when I asked her to turn my water back on when it was hot, and asked her why she went down to the neighbor's house and asked them to call CPS on me. But that's all I have to say.
Okay. Do you prefer to be called Miss Brown then?
Yeah, that is my legal name. And
okay. All right. Thank you. All right. Well, in a case like this, I need to decide whether I'm persuaded by a preponderance of the evidence that harassment has occurred. And, generally harassment's a course of conduct that's directed at a specific person that is harmful to that person, that seriously annoys or alarms or harms them in their mental or physical well-being, and it doesn't serve any lawful purpose. And that any harm that the person suffers is what a reasonable person under those circumstances would suffer. And so, I'm going to take into account the fact that the petitioner here holds a political office, and that people who are in political office are expected to have to deal with constituents who might not be happy with them. And there might be, heated words, there might be things said that are, pointed and sharp and critical. And that's all part of what it means to occupy a public position sometimes, especially one, a political one. And so that's certainly something that comes with the territory, so to speak. But on the other hand, there are lines and boundaries. And so even if a person is in a political position and they're just out living their lives and running their own business and doing the normal things that anyone would do, and then being subject to, basically being accosted on the street or accosted outside of the confines of their job and berated or, threatened or tormented, especially about official business. I mean, this business with whether the water is shut off or not is an administrative act that is done in a proprietary capacity by the city utility. And then focusing in on the mayor because the mayor is just the most obvious person who represents the city, and then getting, in a position to torment her in her off hours and make her, I can't see this as anything other than an attempt to intimidate her to get the water turned back on, which is happening apparently because you don't qualify to have your water turned back on by the normal process. And that's not okay. That isn't okay to do to anyone in a political position. Even though, as I said, people in a political position are expected to kind of have a tough skin and take a lot of criticism, more than probably the average person. But that's not what this is. This is unreasonable. It's not something that a person in a political position should have to tolerate, especially because it's clearly being done as an act of retaliation for administrative acts that are done by the city. And so I do find by preponderance of the evidence that harassment has been proven here, and I am going to issue an anti-harassment order, which I believe will be like the temporary order that was issued a couple of weeks ago. In other words, the provisions of that would be the same. All right, so that'll be my ruling. I'm going to commit that to writing, and then both of you are going to get copies of this order.
Your Honor,
I'm sorry, who was that?
that was me. I was just,
Yes.
she works at the town hall, so I can't go down there.
I'm going to address that separately, so just hang on.
Yeah.
Hey guys, the Irish Demon here, back with another video. We got a Karen in court. You can just tell straight away, off the rip, what kind of lady, what kind of woman this one is. Turns out she was incredibly violent to her husband, and he tells his side of it. Then she tells her side of it, and when she eventually starts to apologize for her behavior, she uses that opportunity to basically blame the guy. She switches on the old crocodile tears, but this judge is totally unmoved. Let's get stuck in.
State versus Cremode, CR 2023-34. I'll note Ms. Cremode is present in custody in person, represented by Mr. Dean. Mr. Beckwith is here from the County Attorney's Office. We have Mr. Sheffer from the Probation Department appearing remotely. I'll note that we have the victim in the underlying matter, Mr. Cremode, with us as well. Mr. Dean, is your client ready to move forward with disposition? Yes, sir. Okay, and Ms. Cremode, can you tell me your full true name, ma'am? Mr. Dean, can you turn on the microphone? Just tap it. Okay, there you go. Okay, Ms. Cremode.
Barbara Lee Kermode.
Okay, and Ms. Kermode, what's your date of birth?
64.
Based on the court's prior finding, it is the judgment of the court that you violated the terms of your probation for the crime of aggravated assault, domestic violence, with the date of violation of January 24th of 2023, a Class 3 felony. I've reviewed the pre-sentence report that was prepared by Mr. Sheffer. Mr. Sheffer is recommending a mitigated term in the Department of Corrections. I'll let the parties know that I am leaning towards a term in the Department of Corrections. I do believe at this point a mitigated term is appropriate. I'll hear from the parties in just a moment. Mr. Sheffer, let me hear from you first. Do you have anything additional beyond what's in your pre-sentence report?
Your Honor, I do. I received a phone call from one of the jail staff 4 days ago and it was reported to probation that the defendant has continued to contact her husband using her tablet while in jail. The jail staff reported that this was some pretty disturbing and concerning contact. And so, Your Honor, given in light of that, probation would ask the court to consider a presumptive sentence in this case, because, Your Honor, this defendant has continued to disregard the orders of the court as well as probation. We've done everything possible to stop that contact with the victim, but it has continued, Judge, and so I just wanted to bring that to light, Judge.
Okay, thank you, Mr. Sheffer. Mr. Beckwith, anything the state would like to add?
The state recommends 2.5 years in Department of Corrections. And also, we have a victim here that would like to read something on the record.
Mark, do you have a microphone we can get to Mr.? Oh, good. Mark's ahead of me. Okay. Can you tell me your name, sir?
James Kermode.
Okay. And Mr. Kermode, what would you like to tell me?
Judge Wright, you know this case since you've been here, been on it from the beginning, so I don't have to go over what has happened. Barbara has worked to get it through her classes. She has taken domestic violence, anger management, and victims of domestic violence. She has been through counseling just as well as we have. However, our couples counseling did not go well. Every time our counselor would say something that Barbara disagreed with, she would either shut down or walk out of counseling. When Barbara went through her classes as well as her counseling, I feel she just tells them what they want to hear so she can get through the classes. When Barbara and I are together, she is a totally different person. She is constantly angry with me. She constantly blames me for all that has happened. Barbara has begun to curse at me, falsely accuse me, belittle, and threaten me. There are 2 cases that are still pending. One is where she falsely accused me of pointing a weapon at her, which was proven by video to be wrong. And the second case is where she threatened to burn the house down and cause bodily harm to me. That was not the first time she has threatened me. Barbara always says that everything she asks me to do for her, I say no. I've done everything possibly that I can do for Barbara. I've paid all of her bills, provided her with a car, and paid her rent. The only thing I've said no to is she constantly requests that she wants to come home. She wants to live like we did prior to the incident on January 24th, which obviously didn't work very well. Prior to Barbara coming home, I've asked her to change the way she treats me. I've asked her to quit cursing, belittling, falsely accusing, and threatening me. Barbara just keeps telling me that I can't change her, and she refuses to change any of her behaviors. Unfortunately, I don't think Barbara has taken her probation seriously. I hope she can realize how serious this case is. Barbara doesn't understand after the incident on January 24th that I have to feel safe in our own home, and with her behaviors that I don't feel safe when she's around. I don't know what further I can do for her or what further probation can do, so I leave that up to you, Judge.
Thank you, sir. Okay, Mr. Dean, I'll hear from you and or your clients.
Well, Judge, I'd like to focus on what Ms. Cremode admitted to. I know there's a lot of allegations flying around, all of them unproven, none of which have been admitted to. The only thing admitted to is that Ms. Cremode did not report a police contact. That is a violation. I would say, Judge, that if in that case, according to the pre-sentence report and from what I've heard from my conversations with Ms. Cremode, Mrs. Cremode, is that on March 19th, 2025, that she had a medical incident relating to her diabetes. She was transported to Banner Thunderbird Hospital in Phoenix, where she received treatment for blood sugar-related issues. It was referred to as a police motor assist, because when she had problems, she had gone off and was essentially illegally parked in the median while medical personnel responded, waiting for medical personnel to respond. Now, I know a lot of probation officers have very different ideas about what police contact means. Some of them say, look, if it's a civil traffic ticket, no big deal, but I want you to report to me if you've had any criminal contact related to a criminal incident. Here, there wasn't even a civil citation. There were medical personnel, police officers. Yes, if we're technical about that requirement, then yes, she had contact with the police, but she was in the midst of a diabetic episode for which she was treated shortly thereafter. I think that's a mitigating circumstance. Might not be a defense, but a mitigating circumstances insofar as the degree to which she could conform her actions to the requirements of the law in the way that diabetic episodes can impair someone's cognitive thinking. That's what she's here for the court to consider, is that allegation that she admitted to. And I don't think that that's worth sending her to prison. It seems to me to be rather technical in its nature. She was under duress and cognitive impairment because of the diabetic episode. But it is a violation. It just doesn't seem to me to be the type of violation that would warrant a revocation, and in particular, a sentence of 2.5 years as a consequence of that. I think the case is appropriate for reinstatement. I understand there are some issues with, I think there's some mental health issues underlying. It's interesting, as I was reading the pre-sentence report, it seemed like there's a lot of things she should be congratulated about. In the evaluation, I'm reading it sounded to me like we're leading up to a probation reinstatement recommendation, but I was surprised that, I guess, the probation officer felt despite all of that progress and all of those accomplishments, she should be revoked. That recommendation just didn't seem to jive with what I was reading in the pre-sentence report, predisposition report. So I would ask the court to consider reinstatement as what's in the interest of justice, but if for some reason, Judge, you do feel it's appropriate to revoke her, then certainly I would recommend that and request that you impose no more than the mitigated term in this case.
Would your client like to be heard today?
I believe so.
Yes,
Okay, go ahead, ma'am.
I have worked hard and diligent to meet the requirements. And I've gone to extra classes. I'm doing classes at the jail. I'm working on it. Mr. Cremode doesn't seem to feel that any place that I've been to, and I've been to maybe 9 or 10, that haven't worked on us. It wasn't about us. So we made a deal that if we did, couples counseling, that I would be able to come home. And then he changed it on me. It's like, he doesn't want to do it that way. He came up with these, I can't accuse, I can't belittle, I can't do any of this other stuff that he's done to me as well. He's not innocent in all of this. But everything that I've done, he has said that it doesn't meet his standards. So it's very frustrating and maddening to be told that we make a deal and he follows out of it, that he can change it on a whim. That's not something a husband and wife does. He's not innocent in all of this. He had PTSD for 9 years and he took it out on me at home. I wanted to leave and he said if I left I'd get nothing. He's now threatening me to talk to you about giving him the house and all our assets, that I am not entitled to anything. It's my house too. It's my stuff too. I worked for it too. And he's going to take it all away. He's going to talk to you about taking everything away. Wouldn't you be mad? Wouldn't you be upset? I'm sorry this all happened, and I've apologized 100,000 times, and I've worked hard, and everything I've done is not good enough, according to him. I've been in Tucson. I wasn't supposed to be. I found out that I needed to move, that I needed to be up in Gila County. I had no probation support down there at all. I had to always come up here for UAs. Called Scott. I've had phone problems. I had my phone replaced twice. I did the art meetings, and for whatever reason, the art meetings didn't come through on my phone. It was always changed, so Tyler would have to resend the link for me to get onto the art meetings. And that happened quite a few times. I've done everything I've been told and extra. I've learned to be humble. I've learned that what I did was wrong. But when you're constantly pushed from the other side that you're wrong, that you haven't done enough, where it took two of us to get to this point, but I'm the one doing all the work. It took two. I've been in contact with him because he got hurt again at home. This is the third time he's been hurt. I wasn't there. I don't want to get blamed for it. I want my marriage to work. I want him to be healthy. This last time the dog pulled his arm out of the socket and now he has to have surgery. Nobody to take him, nobody to take care of him, nobody to take care of our house, nobody to take care of our animals. I wish you would put me back on probation and lift the order of not being on the property. Change in behavior takes two. But when you're constantly knocked down and belittled, it's hard. I'm doing classes in jail. The certificates are on there. I've been working on it. It just doesn't meet his standards. I've asked to have a third person involved in our conversation, and he won't do it. He holds everything. And I want us to work it out. I want to be off of probation. I've worked so hard for all of that. Extra classes. I have notes, they're not here, but he has the binders. He has my letters of recommendations from people who know me that can prove that I've worked really hard on everything. I stayed in a boarding house with a pastor's family. I have a letter somewhere. He has them. I had him in the car the day I had the accident, and I asked him not to take the stuff out because I would need him here, and he took them all out, and now he can't find them. I've worked hard. I know what I've done is wrong. Yeah. I'm okay.
Thank you, Mr. Dean, Ms. Cremode. Okay. The court has considered the following aggravators and mitigators. Aggravators, as originally alleged, the infliction of serious physical injury, victim harm, and the use of a weapon. The court will find an additional aggravator of repeated unwillingness to follow probation directives. As far as mitigators, I'll find her admission and her mental and physical health as mitigators. Considering all of those, the court finds that probation is no longer appropriate. The court does find that a mitigated term is appropriate. It is the judgment and sentence of the court that the defendant's probation is revoked. She'll be sentenced to a mitigated term of 3 years in the Department of Corrections. That sentence will date from today's date. I'll find that she has 98 days credit. I'll order that she serve a term of community supervision pursuant to statute. I'll order that all outstanding fines and fees be reduced to a criminal restitution lien and entered into the tax intercept program upon her absolute discharge from the Department of Corrections. Order that the Department of Corrections notify the clerk of court of the defendant's final release type and date. You have the right to petition for post-conviction relief from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one would be appointed to you. If you cannot afford copies of the necessary records and transcripts, they can also be provided to you at no cost. If you want to petition for post-conviction relief, you'll need to do so within 90 days of today's date, or you lose the right to seek that review. I'm going to have you come up, sign for your review rights, and provide fingerprints to us. Mr. Dean, anything else in this matter?
Nothing further. Thank you, Judge.
Mr. Beckwith?
No, Your Honor.
Ma'am, if you come up, we'll have you come up here to Mark. He'll help you with the fingerprints. Did you start the form? Go to jail.
Group Holdings, LLC.
Azara Staffel on behalf of myself and my family.
Okay, where are we on this?
Your Honor, this is our motion to seek distribution of the funds held in the court's escrow account related to this case. Just to recap, two $5,000 payments total, which was the lease payment amount, incidentally, were placed into the account pursuant to the standard escrow order that was entered during the pendency of the case in chief. And then subsequent to the issuance of a judgment of possession, there was an appeal, and Your Honor issued, entered another order, a bond on appeal, yes, under which two additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond. That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the appeal. So there are no pending appeals on this matter, Your Honor. The matter is final and closed. And as an administrative action, I would ask that the court authorize the distribution of those monies to my client. Thank you.
Response.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter complained against.
Why was it an injunct? It wasn't an injunctive bond.
It should have been because we applied for restraining order against the plaintiff and it wasn't granted. But this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back, and we also paid for over $44,000 of expenses that we paid the property taxes, we paid the homeowners insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it, and therefore we are entitled to this $20,000.
Why don't we get clear, first of all, what the $20,000 is? The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed. That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, with 2 months of that. Albeit late, there were 2 payments put in. Judgment was rendered. You appealed that judgment. Also pursuant to the court rules, in, again, Chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever, or ordered whatever bond, but where there has been an escrow order, that escrow order then effectively becomes the bond on appeal. And that's what happened. And so then there were 2 additional payments prior to the dismissal of the appeal that then makes the $20,000. So that we're all, whether we're not on the same, we can all be on the same page or not. That's what happened, and that's why the $20,000 is there. I don't know what you're talking about in terms of objective relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that, and the $5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And the return has been filed by the sheriff.
Got it. So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the $20,000 should be paid over to the plaintiff because of your occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
What about our security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale, which they breached the contract and they never did, Your Honor?
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
There's the Security Deposit Act, which governs how that is how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before you?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here and is not before the court.
I'm raising that today, according to ex parte emergency motion and filed, Your Honor.
I don't know that it would be, I don't know that all of the compliance, Gustavo, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be ripe to even be heard before the court. I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That's not how it works.
Okay, I petition again, Your Honor.
Well, you can do what you want, Ms. Staffeld. I'm just telling you, I'm not dealing with the security deposit. I'm just not, it's not before me. The only issue before me is the $20,000 as an escrow and its disbursement. Is there anything else you want to say?
Thank you for evicting me and my family out of our house, Your Honor. God bless you.
Well, I guess you're welcome. I didn't evict you. You evicted yourself by not complying with the lease. So don't try to put that on the court. Sometimes people, when they have problems in life, have to take the responsibility for their own actions and can't sit there and try to blame the plaintiff or blame the court or blame everybody else in the world. Those are the people that have real problems because they can't take it on themselves to do the right thing. So to the extent I made you realize that, you're welcome. It's the order of the court that $20,000 will be paid to the plaintiff. Counsel for the plaintiff prepare that order so that I can then give that to the clerk and we can disperse that.
Thank you so much, Your Honor. Appreciate your time.
We know this is going to happen, so we are submitting this right now.
Thank you. They're ready.
All right, City of
Yes,
Detroit.
I'm here, Judge.
Okay, here we go. City of Detroit, good morning to you, good afternoon to you, Ms. Lane. City of Detroit versus Sade Lane, case number SP 130-8461, counts 1 and counts 2. SP 140-3385, count 1. SP 143-2823, counts 1 and counts 2. SP 153-48221. SP 172-3233, counts 1 and counts 2. SP 172-3292, counts 1 and counts 2. SP 172-3336, counts 1 and counts 2. And SP 172-59881. Appears for the record, please.
Aaron Otry, I'm about for Ms. Sade Lane. Ms. Lane, can you state your full name? Ms. Lane?
Oh, I'm sorry. What did you say, attorney?
Can you state your full name?
Sade Renee Lane.
All right, start your video now. Today is the date and time set for a pretrial. What does your client want to do?
There's a resolution of the matter, Your Honor. She's gonna plead to 2 counts of improper play for no insurance. and then limited access 6 to 10, and blockading. And she's asking for community services to do community service.
You want to take the deal, ma'am? Ms. Lane?
Yes, I'm sorry, Judge. So when I got my speaker on, I gotta hold my phone up because I can't hear and see at the same time. I mean, and you see my face. So.
All right. I see your face now, so you can turn your camera off. All right.
Okay.
So let me see. Can you raise your right hand, please? Do you swear or affirm, tell the truth, whole truth, nothing but the truth?
Yes.
All right, you can put your hand down. Okay, you go ahead and do what you need to do. All right. You understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fine?
Yes.
You understand that you have an absolute right to a trial?
Yes, I do.
Mr. Ogletree went over your other advice or rights in the breakout room, did he not?
Sorry, Your Honor.
Did Mr. Ogletree go over your other advice or rights at some point in the breakout room?
Yes, they did.
You understood those rights?
Yes.
You have any questions about those rights?
I don't. I asked them already.
You know by taking this deal, you're gonna give those rights up?
Yes.
And has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to May the 7th, 2025, at around 3:36 p.m. in the city of Detroit, in the area of Evergreen and Schoolcraft. Did you have an occasion on that day to come encounter with the Detroit Police Department?
Yeah, I know the case you're referring to.
And were you operating a motor vehicle on that day?
Yes, I was.
And was that your car?
No, it was a rental, and I actually had my license on me at the time, but I couldn't find them. Officer Bennett, I pulled right up on him to show him my license, and he said, "Go to court. I'm gonna put you through a driver's course." Like, he didn't want to hear me.
So, Officer Bennett, did you have a valid license? That's the question.
Yes, it was. Yes.
Run a driver's license, please. Because he wrote you for suspended license as well.
Oh, that's not the ticket I got. I only got over the speed limit, and he got me for not having my license on me.
Yeah. See when these other tickets. You got a lot of. It seemed like you got a lot of tickets. See if they were all issued at the same time. All these tickets were issued at the same time.
By the same officer.
Yeah, I know. And he wrote you for a suspended license, and he wrote you for no ops, and he wrote you for no insurance, and he wrote you for speeding, and he wrote you for expired plate.
Anything that was in May, I had a rental for like a month and a half. So
Hold on 1 second.
I had insurance on a rental.
1 second.
Okay, hold on, Ms. Lane. Let the court do what's.
Evergreen and Linden.
I'm sorry.
Evergreen and Linden was one ticket on 5/7/2025. And then on 5/7/2025, Evergreen and Schoolcraft. You got pulled over twice in one day?
Yes, I did.
Just a few minutes behind the other.
Yes, Your Honor.
So you're just ripping and running up and down that Evergreen and
Your Honor, I'm like the taxi jitney for my entire family. Well, whenever I have any free time, I have to rip and run.
You need to be charging them so you can get your valid license. Let's see if you had a license on that day.
Yes, I did.
That's what you say.
Yeah, I know I did because I was able to get my rental car.
I'm not going off of that now.
Okay.
I'm not going off of that. All right, when is this date? This date, 5/7/2025. It says your license was suspended out of Taylor. That goes 5/22. That's after this date. I don't. The fact that you got a rental car does not tell me that your license is valid.
So it say my license was suspended in May at the end of May. Correct.
I mean, it
This
says here,
Officer Bennett pulled me over on May the 7th.
I understand that. I understand that.
And no insurance. That wasn't even my
Miss
car.
Miss
So you know
Miss Lane, just let the court do what it's doing.
Okay.
Based on the reading of this, I cannot confirm that her license was suspended at that time.
It wasn't, Your Honor.
I know you say so. I know that. I heard you. That's why I'm taking a opportunity to look at it.
Okay. And Your Honor, can I just note, I know what you're looking at. It's definitely not a reflection of who I am. There are a lot of speeding tickets, but like I said,
Miss Lane,
huh?
I'm not saying it's a reflection of who you are, okay? These are traffic offenders. I'm not saying that Miss Lane is the worst person on the face of this earth because she got pulled over and didn't have her license. I'm not saying that, all right?
Okay.
All right. So all I can say is you didn't have that license on that date, and that is a misdemeanor. I'll find her guilty of the amended count of allowing instead of the improper plate. Same difference. Okay. We have 2 counts of amended improper plate. Let's see if we can. That's for the no-ops. That's for the no-ops. What I'll do, did you have valid insurance on that day?
Yes, Your Honor. I was not even in. That's my point. I'm saying the same thing over and over again. But how could I have improper plates or no insurance on a car that does not belong to me that I'm renting? Like, that's a lie.
You're not. I don't think that Mr. Ogletree is explaining it to you. Obviously, what I'm going to try to explain it to you. The improper plate plea is amended. So just like you pled to the no-ops, you said I didn't have an operator's license. I'm guilty of that, Judge. Yeah. Instead of you pleading straight up to the no-ops, which would abstract on your license, the city has offered you the ability to plead to allowing, so that the allowing will not abstract. You'll pay the fine or do the community service, and we'll dismiss it.
Okay, yeah, that's my lawyer explained.
Same as with a no insurance plea. A no insurance plea, if you say I didn't have insurance, then it'll be an improper plate. That doesn't abstract, so you don't carry any points, and we'll dismiss that upon payment or something. That's what the improper plates and the allowings and the amended counts mean. Okay.
Okay.
She understands that, Your Honor. The only part is the court has To dismiss.
She didn't understand it, it seemed like, because she didn't understand it by what she just said to the court. All right, now, did you have insurance on that day? Is the question.
Yes.
Okay, the question is yes, the answer is yes. All right, let me do this. Let me carry your attention. Let's see, let's carry your attention back to December the 22nd, 2023 at around 10:10 a.m. in the city of Detroit. And the officer Bennett again, in the area of Plymouth and Foss. Did you have an occasion on that day to come encounter with the Detroit Police Department?
Yeah, I had a run-in with Bennett.
Again, you keep having run-ins with Bennett, don't you?
Bennett is looking for me in my eyes, but that's another story. And I asked him that when I last saw him, but okay.
All right. Yeah. On that date and time, ma'am, did you have a valid license on that day?
December 23, no, I did not.
Okay, December 22nd, 2023. Okay. All right. And you were operating that motor vehicle, is that correct?
Correct.
All right, find her guilty of the amended count of allowing on that. So instead of improper plates, it will be 2 counts of amended counts of allowing. Were you speeding on that first date, ma'am?
I was.
All right. And what was the other, was it for the one blocking traffic? Were you speeding both times on that date?
Yes.
On both times on that same day you got that ticket?
I believe so, Your Honor.
Okay, so if you weren't speeding, then Officer Bennett would have no reason to pull you over, would he?
Guess not.
Unless Officer Bennett knew or felt he knew that you didn't have a valid driver's license or didn't have insurance or something, right? But speeding got the attention of the officer. Would you agree with that?
I would agree, and I would agree that my car was distinctive, and that I know that.
All right, but that has nothing to do with that has nothing to do with you speeding, though. Well, I mean, I guess it does. It stands out even more. Your speeding and your car is distinctive, right?
Correct, Your Honor.
And you're drawing attention to yourself, right?
Yes.
And it's Officer Bennett's job to pull people over that are speeding. Correct? She doesn't want to answer that one.
No, because I really just if you can look at my record, because I know it's really long, but I just received my license. And ever since I received it, this officer he keep giving me tickets. I'm not.
But you just said that you were speeding, ma'am. What do you think the officer's gonna do when you're speeding?
5 miles over. Okay. All right. Correct. You're right.
Right. Over. You gotta accept responsibility for it.
I'm accepting responsibility, Your Honor. Can you see I did community service? I only have speeding tickets for real. I have really did try to get my license. It took a lot for me to get them.
All right, so you're not respecting it then, because if you continue to speed, then you're going to continue to get tickets and potentially get tickets, and that's going to be the way it goes. So you have to learn to slow down. And what's going to make you learn to slow down? I don't know. That's all it is to it. You're not just speeding, you got 26 to 30 over. You have 16 to 20 over. You got 21 to 25 over. You got 6 to 10 over. You got 6 to 10 over. You got 6 to 10 over. What are you crying and complaining about? Turn your camera on. I did that, I'm sorry. Huh?
You said, what am I complaining about? I'm complaining because
What are you complaining about? You're doing 21, 30 miles an hour over the speed limit continually. And you're going to sit here and blame Officer Bennett for pulling you over. Now, I'll tell you another.
Watching, Your Honor, I'm going to agree to what's on paper, 25 miles. If I'm writing down Evergreen, how can I go 65 up Evergreen, Your Honor? That would be 20 miles over. If I'm writing down Plymouth, these are the streets he's getting me at. If I'm writing down Plymouth.
Happens all the time. Happens all the time.
It happens all the time, and he's the one bringing in most of the people, and it's going to be believable because he put it down on paper. Just like it was just a lie you just told me that said that I didn't have no insurance on a rental car. Like, and everything that I'm saying is you're not understanding what I'm saying? And after that was just that was a lie?
We're going back.
Calm down, Ms. Lane.
No, we're going back to this. You admitted to speeding, ma'am. You admitted to that.
I did admit that.
You said you sped. You said so.
Yes, I did. But not 30 miles an hour up Evergreen. That's going
well,
like
I'm not, listen, I'm talking about the past you bled. You got 30 miles an hour back years ago, 26 to 30. On this occasion, it said you were going 21 to 25 miles an hour over. On another occasion, it said you were going 16 to 20 miles an hour over. On another occasion, it said you were going 6 to 10 miles an hour over. On another 2 occasions, it said you were going 6 to 10 miles an hour over.
All right, Your Honor.
So you admitted to that. Now, I'm tired of people coming in blaming Officer Bennett. Officer Bennett is targeting me. Officer Bennett is doing this.
Ms. Lane. He is, Your Honor. Why is it so hard to believe?
Ms. Lane, calm down.
You're just not gonna get it.
I'll talk to her further, Your Honor.
Well, if I would give a little bit of credence to what she's saying, if she doesn't sit here and admit to speeding all the time, I would give a little bit of credence. But she can't sit here and tell me that Officer Bennett is targeting her when she's admitting to speeding up the street. What is Officer Bennett out there supposed to be doing?
Your Honor, can't you see that that's in the past? Why you bringing up old shit? I told you I just got my license back, and I've been working on that. Okay.
I can't get you to understand any better, ma'am. I got other people. I just can't get you to understand any better. You're just not going to accept really the responsibility fully.
I'm accepting the responsibility. That's why I took the plea, because
I give you that. I'll give you that. I'll give you that. But we're going back and forth about Officer Bennett targeting you. You don't understand that you're giving him reason to pull you over. That's all I'm saying.
I do.
That's it. You're giving him reason to do it. And if you keep on speeding, he's probably going to pull you over again if he sees you. That's all it is about. All right, what do you want to do with these? Do you want to do, you said you want to do community service?
Yes, she wants to do community service.
For everything, ma'am, to clear up everything?
Yes, to clear up everything.
Mr. Lyons, you've been real comfortable this whole time. I'm gonna need you to get up.
That was lied about and didn't I just.
Ms. Lane,
What is
mute
she
your
saying
device.
now? What are you saying now, Ms. Lane?
You said mute my phone?
No, what was the comment you had?
The comment was, it really doesn't matter when you come to court because it was just a proven lie. But being by that, I didn't take what you said, but I hear everything you're saying. Now I'm back onto my past. We talking about the cases that's happening now, and it was proven that I was lied on, just like them other court things where it say I did 26 over. If I agreed to that, I know that was a lie. Them are all residential streets. How could I do 26 over? I can tell you the areas I be. How can I do 26 over on Evergreen? How can I do 26 over on Plymouth? That's what I'm saying. I'm trying to prove that what I'm saying, maybe I'm not honest. I'm honest because I'm saying I was speeding, but maybe them speeding tickets is not so honest. That's what I'm saying, but it doesn't matter because they all speeding tickets. So it's going to look like I'm a speeder. So I'm agreeing to whatever it is, but I know because I was the driver.
All right,
that's why I'm agreeing.
Ms. Lane, you're just not gonna really understand. I don't think you really understand. I don't see how you don't see how somebody can go 20 miles or 30 miles over the speed limit on Evergreen and Plymouth. I drive those streets every day. I see it all the time.
Now with Officer Bennett, he's on that. That's where he worked. So why would I be doing that like that? Like why would I go that fast knowing I'm a see
Miss Lane, let's talk about this offline.
Okay. Yeah, you got to, because it's not doing any good, because you admitted to speeding. Now you're trying to dice it up and say I wasn't going exactly that fast. You're trying to say that. I don't know, but you admitted to speeding. And you always speed.
Yes, Your Honor, I'm a mental speeder, but I'm not a liar.
I didn't say you were a liar.
You say you don't know, meaning that you're not sure what I'm saying to be true. That's what you're saying. But I'm agreeing.
Ms. Lane, I get people in here all day that say I wasn't speeding going that fast. I'm not in the position. I wasn't there. I don't know. And at the end of the day, to the court's eyes, it really doesn't matter how fast you were going when you're taking the deal and saying I was speeding and you're accepting the deal. That's as simple as that. I didn't say whether you were going 20 miles an hour over, but you're putting up the defense that how can I do that on Plymouth or Evergreen? I say it's very easy to do that on Plymouth or Evergreen. I think everybody in here can see people going 20 miles and 30 miles an hour over a Plymouth and Evergreen all day. Except you. You're just saying, I wasn't going that fast. I was going 19 over. Is that what you're saying? I don't know. You're just gonna, let me just get it done. 72 hours of community service will clear everything up. That's all your old stuff and everything. 72 hours of community service. Refer to community service coordinator. Do you have an ink pen?
No. Oh, you said I have an ink pen. Oh, okay. I thought you said I had any questions.
Long one.
Yeah, I have an ink pen.
All right, 313-965-8130. I'll waive the warrant fees. And I'll refer to community service. If you don't hear from them in a week or so, you can always zoom back into the court, or you can call that number to get it set. I'm going to give you until September the 4th. I don't necessarily expect it to be all done, but I expect a very good effort on it to be done. We'll come back on September the 4th and see where you're at, okay?
Okay.
Thank you.
All right, slow down, ma'am, and if Bennett pulls you over and you're doing the speed limit with 10-2 on the wheel and you got all your stuff together, then somebody would entertain that. But by you speeding, nobody's really gonna entertain all the other stuff. You should need to slow down.
All right.
All right, best of luck to you.
Thank you.
Well, all right, Jeffrey Lee. No PSI. I do have a PSI. Have you got the PSI, Miss?
Yes, Judge. We did go over the PSI. We do have some corrections.
All right, let's call it City of Detroit versus Jeffrey Douglas Lee, case number Z8094821. Appearance for the record, please. Come over here.
Good afternoon. Melita Barrett on behalf of Jeffrey Lee.
All right, good morning to you, good afternoon.
Good afternoon, Your Honor. We are here in case 24 CR 1275, State of Ohio versus Colleen M. Kelly. Present in court is the defendant, who's accompanied by her attorney, Mr. Jim Matthews. We were previously here on March 3rd, 2025. At that time, the defendant withdrew her previously entered plea of not guilty and entered a plea of guilty to count 1, possession of cocaine, a felony of the fifth degree, with a voluntary forfeiture of all contraband and instrumentalities. This matter was referred to the Lake County Probation Department for a pre-sentence investigation report, as well as for a drug and alcohol evaluation. Those reports have been prepared. The state has had an opportunity to review them and is ready to proceed with sentencing. There are 51 days of jail time credit. Thank you, Your Honor.
Thank you. They included the. Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. Your Honor, Ms. Kelly does wish to be put on community control. Ideally, from her perspective, the court would consider releasing her, having her attend an intensive outpatient treatment program, permit her to begin enrolling in school and working on rebuilding her relationship with her children. She does have a statement she wishes to read to the court.
Ms. Kelly, you have the right to address the court before your sentence. You can say anything you want. Anything you want to say.
Okay. Your Honor, I'm not going to waste your time. This is a letter I wrote on Wednesday, and I was debating whether or not to send it to you. But pretty much, it says, Honorable Judge Collada, first I'd like to say thank you for taking a few moments of your time to read or listen to what I have to say on my own behalf, since I'm truly the only one who knows who I am. I also like to state that in my opinion, no offense, Mr. Matthews, that Mr. Matthews has not been the best representation for me. And I don't feel that he takes anything into consideration I say or brings it to you. He only responds with something negative, telling me that it won't happen, that you're going to say no to it, that it's going to be denied. And so he kind of puts me already, like feeling at a loss. I'm not going to make excuses for the choices I've made that have led me to the fortunate or unfortunate events in my life, because they were my choices. And I am a true believer that everything happens for a reason, good or bad. And we learn to live with these choices we make, but when it comes to addiction, that's not a choice anyone gets to make, because that gets passed down from generation to the next generation. It's hereditary and genetic for the most part. The reason I say that it's for the most part is because no one's to blame for the disease of addiction itself. But I can say that I have been a stumbling block for my children due to the fact that they have seen me in my active addiction at times and may have condoned them to use as well. When it came to weed, yes, the gateway drug. And I am kind of a crappy mother for that and for allowing them to do that. I would rather have had them doing that around me, though, than to end up doing something and dying like I had. because it was laced with something more dangerous. And how could I say anything when I myself was using as well? Then I'd be nothing more than another hypocrite. I know that I'm a good person. Sometimes I care and worry too much about others, and I forget about myself. And I'm grateful that I've had this time to sit and reflect on so many things, but at the same time, it has made me feel, and as an addict, feelings sometimes aren't always a good thing. But being here, I've learned different coping skills to deal with these, and I finally gotten my medications in my system that I have needed now for a long time. Because not only am I an addict, but I also suffer from or struggle with mental health now as well. And I plan to continue my treatment with Crossroads, possibly Signature Health when needed. I'm planning on enrolling in college for fine arts, maybe a few electives. I have some jobs already lined up. I have phone numbers of other addicts in recovery. I have some physical ailments that I need to look into still. And I have my mind focused on a better life, than the one that I've been living. I'm not saying it's going to be easy, because staying sober is one of the hardest things an addict can and will do. But I know where my heart and mind are. And I know that as long as drugs are involved, I can't have any of those things that I just mentioned. I would like a chance to get my life back and build a relationship again with my children and try to fix what I've broken in my own relationship with certain people. I'd like my children to look at me like they used to, and I want to have them know that I do care about them and love them. I need them more than they need me right now. Sorry. I want my family to be proud of me again and given a chance. I know I can do all of this. I'm not just a lost cause or another dollar sign for anybody.
What's that mean, dollar sign for anybody?
I just feel like a dollar sign to the city, to the jail, to the public defender. Just
They're making money off of you? I'm making money off of you?
every day I sit in the jail, is all I'm saying.
Every day you're in the jail is costing us counting money. We're not making out, we're losing money because you're sitting in jail. $65 a day for everybody that sits over there. You paid that? No, I paid that. They pay, everyone else paid that.
I was under the impression that, I'm sorry, I was under the wrong impression.
No, probably Mr. Matthews told you something and you said he was wrong. He said,
I'm a strong woman with a good heart who wants to change the world and make everything good. But if I'm not good enough for myself, then I'm no good to anyone else. Thank you for your time. I'm sorry I upset you.
so what are you asking for? I guess I don't know what you're asking for, Miss Kelly.
I'm asking just to be given a chance to try to get my life back.
So you're supposed to let you out and you're going to do that all on your own?
No, I already have phone numbers of people that have told me that I could call and they would pick me up. They're in.
How are you going to address the drug issue? Oh, you don't have a drug issue according to you.
I do have a drug issue, yes, sir.
No, he told probation. Told probation you didn't have a drug problem.
I never spoke with probation.
So that lady right there.
On the monitor. Okay. When did I say I didn't have a drug problem?
No, she's not there to answer your questions.
No, I do have a drug addiction. I never said I did not.
So you didn't need treatment, you don't need people telling you what to do with your body, you can do whatever you want with your body. You don't remember any of that?
I'm not making any excuses, Your Honor. I may not have been on my medication at that time either. I have been struggling with mental health, and they finally have given me the medications, and they're working. And I asked if I could continue my mental health treatment with her, and she said yes. I just needed to make an appointment, and she would continue it on the outside of here. She listened to what I asked for. She went ahead and proceeded to give it to me, and so far it's been working. I have been going to meetings in the jail. Every meeting that they have, I go to. I even go to the domestic violence. I've been getting any kind of information that I can get so that I can try to start off on the right foot instead of walking out and...
So you don't remember this? The defendant does not believe she has a problem with drugs. The officer asked the defendant if she believes she needs treatment. She stated no, but I'm sure everyone else thinks I do. I just need people to stay out of my life. What I do with my body is my business, and everyone else should stay out of it. That sounds like someone that thinks they...
I may have said that. I don't know what my day was like that day also, Your Honor.
You think she just made it up?
No, I never said that. I just said I don't know what my day had.
You said you may have said that.
You asked me if I remembered. There's a lot of things I don't remember.
Because of drugs.
You're right. Because of drugs. I just said 2 years ago I did a drug that's the devil's drug, and that was meth. And I'll regret that for my whole life.
You're in a position right now that you can walk out these doors and you're not going to use. You couldn't come to court sober last time you were here, and you were out and about on your own. You deny that too. You deny having used any of those drugs.
No, I said I had smoked weed.
But you tested positive for a lot more than weed.
I don't know if the weed was laced. Nothing is real anymore. It's more of a job anymore. I don't even enjoy doing the drugs. And I'm grateful that I've had this time to sit there because it gave me almost 45 days to start with some kind of a foundation, a strong foundation. I was in the program years ago. I had 5 years. I was a secretary. I was a chairperson. I was doing the events. I'd go to the camp outside. I'd go in early. I'd set up the chairs.
So you're willing to go to inpatient treatment program?
If that's what you feel I need. I mean, I can do the IOPs. I can do house arrest.
That's not what I said.
Inpatient, yes. If that's what you would like me to go to, I will go to an inpatient treatment.
Anything else you'd like to say?
No.
You don't have to. Just make sure you said everything you wanted to say.
No, Your Honor.
Okay. Thank you. Mr. Matthews, anything else on behalf of the defendant?
No, Your Honor.
Mr. Line for the state?
Your Honor, the defendant does have a lengthy criminal history, much of which involves drugs. She has been placed on probation in the past. In her 2017 Cuyahoga County case, she had 6 probation violations before she was sentenced to incarceration. And the same thing occurred in this court in 2020 when she was sentenced to prison for her probation violations. The defendant mentioned today that there's no choice in addiction, but she has the choice to change her life. And her lack of insight is concerning, and coupled with her prior history of failing to comply with terms of probation. She did also not take any responsibility for her behavior in this case. She indicated to probation that the police set her up, and that probation also somehow tampered with her drug testing results. She did pick up new charges while she was out on bond on this case. She has a 2025 case with Mentor where she is scheduled for sentencing and again tested positive while she was out on bond on this case. So for all of those reasons, the state does recommend either a prison sentence or at a minimum that she be placed into NeoCap. Thank you, Your Honor.
Sure wants to talk.
I have reviewed the pre-sentence report and evaluation, drug and alcohol evaluation, pre-sentence report and investigation, drug and alcohol evaluation. It's considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today by Mr. Kelly, the prosecutor, Mr. Matthews, the recommendations. All this is considered by the court in light of purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, Nothing stands out factually indicating it's more or less serious. As for recidivism factors, all of these factors are present, indicating recidivism is more likely in the future, pretty much guaranteed. Defendant has a lengthy, very lengthy criminal history. She's served prison, multiple prison terms before. She has not responded favorably to previously imposed sanctions. There's a lengthy history of probation violations. She's been on probation than me before. She had multiple violations. She had 6 violations in Cuyahoga County. She doesn't follow conditions of probation. And that's just this fact. Our whole history here is just one probation violation after another. She was on bond to me in this case, and she committed another offense. You're shaking your head you didn't commit an offense. You're saying you didn't commit an offense? You're
I'm
set for
sorry?
sentencing.
I'm sorry, Your Honor.
No.
I never said I did not commit an offense.
You're sitting there shaking your head like that. No, that's not true.
I wasn't shaking my head for that.
Okay. She committed a new offense while she was on bond. She violated her bond in this case by showing up to court high as a kite. I don't think I've ever had anyone show up in the condition that she's been in before for court hearing.
I wasn't high that day, Your Honor. I was told by Mr. Matthews that I did not have to go in front of you that day.
So
Him and my fiance both told me.
So what's that mean?
He said that it was just a meeting,
Okay,
and
so-
I was anxious. I hadn't been on my medications.
You tested positive that day. Oh, is that what?
I had smoked weed on Friday.
Is that what they tampered with?
Your Honor, I never said that they tampered with my. I never said that.
Well, you showed your.
I
tested
smoked weed
positive.
on Friday.
Huh?
I smoked weed on Friday, not on the day that I came in. I was anxious. I was a nervous wreck because sitting in jail does nothing for someone who's
You
got an
tested positive
addiction.
for amphetamines, methamphetamines, and cocaine.
It doesn't mean that that's what I did. I smoked weed on
Doesn't mean
Friday.
that's what you did. You mean you can use one thing, which you didn't even test positive for, and it comes back positive.
You told me
for,
that it came up positive for weed.
positive for
When I brought
amphetamines,
it up to
amphetamine-
you, and
know,
I
I'm
said
not- I'm not
it should have never come up, or I
I'm
said
not
the
arguing
weed
with
never
you.
came up.
Fact of the matter is, you used on Friday, and you were on bond, and you weren't supposed to use. She's not here to answer your questions, all right? She's not going to sit here like you treated her during the PSR and be rude to her and be demanding and say, I want this and I want that. Same way you treated the gal from the OCAP.
I was not disrespectful to her.
You're very disrespectful. Absolutely zero remorse in this case. She actually denies committing the crime in this offense to the probation department. Those are all factors indicating recidivism is more likely. There's nothing indicating it's not. On the 29-29-13B1, court finds the defendant previously served a prison term. Prison is consistent with the purposes and principles of sentencing. Questions whether you're amenable to community control sanctions. And the fact of the matter is, you're here with us here. You deny even committing the offenses that you pled guilty to. So you came in and pled guilty, but then you went to probation and denied even doing this. You claim you didn't have a drug problem to the probation department, though you tested positive multiple times. You had a horrible attitude with the probation department. You were rude. You were questioning them. Very similar to probably
I
what
was
you're doing.
upset, Your Honor.
You gonna let me talk? I don't care about your explanations. I told you you need to go there and be open and honest with them and be respectful. And you don't go in there and be rude to them and treat them the way you treated them and be demanding. You're in no position to be demanding that they give you copies of everything. That's not the way it works.
I asked her for a copy, and she said I didn't have the right to have one.
Right, 100%
That
right.
it wasn't my. If it
Then
was
you demanded
my,
the same thing from the gal from NeoCap.
I asked for a copy. If it had to do with my information, that's public record.
No, it's not. So you're the lawyer now. You know all this.
No, I'm not a lawyer.
Well, that's
I
not
didn't
public
go-
record. Those reports aren't public record. And when they told you that you weren't going to get them, you treat them rudely and you're insistent and questioning them. That's not the way it goes. You told probation you don't need treatment. You can come in here on the day of your sentencing and change your whole tune, but you went over there, and I told you when you go over there, you need to be open and honest with them about everything that's going on. And then you show up here, again, when you know that you could be going to prison, and you change everything you said to them in terms of, now I think I have a drug problem. I do need treatment. That's not what you said to them. Nobody's going to tell you what to do with your body. You don't need treatment. You've been sitting there for 40 days now or whatever it is, and you're sober now, and you're good to go. That shows zero insight. Prison is consistent with the purposes and principles of sentencing. There's just no way, based on your history, with the multiple probation violations, and then the attitude you displayed here to the probation department, that you're amenable to community control sanctions. Therefore, it's a sentence of this court that the defendant serve a term in prison of 9 months. She has credit for 51 days she's already served. Need to advise you upon your release. You may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer or transitional control, and the defendant's ordered to pay all costs in this action. Is there anything else for the record, Ms. Timmerline?
Just a voluntary forfeiture, Your Honor.
Or contraband seized to be forfeited?
Go ahead. I'll let you address mine before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that there's a case out of 14A2, 25203, okay, actually, you know what, I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that I.
Out of my court?
Oh, sorry, 14.8.2.
So what would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far as this matters, yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes. Well, the charged alleged conduct in the police report, as far as that report, which we have not had any substantive hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have stood mute on that matter. Screenshots. Yeah, and we do. I mean, we are gathering discovery on the matter, and I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell. Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address.
You're saying the bond I set was excessive?
Well, at present, given the current circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her.
Where are the other two children?
My kids were left at home attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home attended for 2.5 weeks. I sent cash up money to them.
This is Ms. McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with their grandmother.
I got the move. I just want you to know that, sir.
And Ms. McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just.
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir, and that is taken care of. And it was you prosecuted her rapist, and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, if the court's familiar with this case, I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is being stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police, she had to have a text a friend to call police because she was so afraid of her. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case, and I believe in our bond form, our original request was $100,000, so I think $50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say I don't believe. I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case, with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider.
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an act.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact. In addition to the fact that there would be a GPS tether as part of her bond conditions.
And I did also make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I mean, I do have concerns. She does have an assault history, and given this case, I have concerns that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will continue.
And Your Honor, did we set a date?
I don't know. July 3rd, 1 week out.